Now we're going to be finishing up our discussion of civil liberties, moving beyond the First Amendment into the civil liberties and rights guaranteed by the remaining Bill of Rights. We're going to start out with the Second Amendment, which talks about the right to bear arms. Yes, it's guaranteed that we do have the right to own and possess guns and form militias, but we do need to realize that states are allowed to limit that ownership in many ways, and it's because of our federal system of government where the states can kind of have different policies. There are different limitations depending on the state you live in regarding things like concealed weapons, concealed carry laws, basically, background checks and limits for those with mental illness, what types of guns can be carried in schools and government buildings, and limits on other dangerous or unusual weapons, and also restrictions for qualifying for ownership or the right to sell guns. Different states have different licensing procedures, so remember, if you have a license to have a gun in one state doesn't mean it's legal in another state. And remember also that the Supreme Court finally did incorporate the Second Amendment to the states, so states cannot take away your right to own a gun, according to District of Columbia versus Heller and McDonald versus United States. But know that this is still a controversial issue. There have been limits on guns in the past, such as the Brady Bill, which limited handguns, and the assault rifle ban that has expired. But with the recent increase in gun violence, there's been new proposed limits that are being debated. Moving on to the Fourth through the Eighth Amendments, we're going to focus on the rights of defendants, of those accused of a crime. The Fourth and the Eighth through Eighth Amendments focus on things like searches and seizures, self-incrimination, your right to counsel, which is a lawyer or an attorney, your right to a speedy and public trial, and your right to no cruel and unusual punishment. So this chart here kind of takes you through the stages of the criminal justice system. So first is about the evidence being gathered, and the fact that we have a protection from unreasonable searches and seizures in the Fourth Amendment. Once they've gathered the amendment, they cast suspicion on those who they think might be, accused of the crime, but they can't take away your writ of habeas corpus, meaning they can't imprison you without evidence to hold you. Okay? Then they'll make the arrest, and in the Sixth Amendment, they guarantee you the right of assistance of counsel. And they'll interrogate you, and they can't force you to self-incriminate, and that's where you hear people plead the Fifth. They also can't charge you excessive bail, which means like the money you need to get out of jail until your trial. It has to be relevant to the crime, and that's according to the Eighth Amendment. Once the trial is being held, it has to be a speedy and public trial by an impartial jury. That's the Sixth Amendment. And you cannot be tried twice for the same crime. That's double jeopardy in the Fifth Amendment. And it is required to have a trial by jury. That's in Article 3, Section 2. And you do have the right to confront your witnesses according to the Sixth Amendment. So they have to testify in front of you if you're being charged with a crime. And lastly, if you're found guilty, they impose punishment, but that punishment cannot be cruel or unusual, according to the Eighth Amendment. So let's go through these a little bit more detailed. Searches and seizures, basically it says that they cannot search you or seize your property without a warrant or probable cause. A warrant would be a legal specific document stating what they have the right to take from your home or look for in your wherever home or property. Or probable cause is the sign that there's immediate need to go in. Maybe somebody's in danger, there's violence, they can witness the act of crime happening, or sometimes it's the fear that the evidence could be removed. If evidence is obtained illegally, it can be excluded from trial, and that is called the exclusionary rule. And that was verified in Weeks versus the United States and incorporated to the states in Mapp versus Ohio. So those are some details on searches and seizures. I know you may have questions about those things, so let's go over how this kind of works. Basically, there are different zones of privacy in your life. Where you have the most privacy is in your home. The police are most definitely going to need a warrant to search your home or your land, unless there is plain sight evidence or fear of somebody being in danger. Your property kind of falls under that as well. Your property is very closely held in privacy. But next it becomes a little less private when we get into your car or in public. When your car is being driven on the street or when you're out in public, you could present a danger to others, so the police are going to need less justification to be able to search you if they if there's anything in plain sight. If they feel like you could drive away, they can hold you. Also, they can pat you down to see if they feel any weapons or things like that. And the least privacy is in school, obviously, because the school has a responsibility to provide safety for its students, so they can always search you in school, or almost always. Some exceptions to when they cannot search you, exceptions to when they don't need a warrant. Aerial searches with evidence in plain view can be obtained without a warrant. So say they can fly over an area and see marijuana plants in the backyard or environmental violations happening. They can use that as evidence if it can be seen just from plain view, not from necessarily with binoculars, but from plain view. Also, random roadside checks for drunk drivers, as long as it's random, is allowed. Also, using narcotics dogs for use at a routine stop for speeding. So say they stop you for speeding, and then they have a narcotics dog, they can use that at a routine stop. And also, it's okay to do warrantless car stops and stop and frisk encounters with pedestrians based on reasonable suspicion. So they can stop you if there's a reason to be suspicious, maybe you're swerving, things like that, and they can stop and frisk those who they encounter who are suspicious, maybe behaving erratically, maybe, seeming drunk, acting violent, things like that. So there are some exceptions where they don't need to have a warrant and the exclusionary rule does not pertain. Also, if there's inevitable discovery, meaning that if the evidence would have been discovered regardless of the warrant. There was this case where a man dumped a body on the side of the road, and he told them where it was without being read his rights, and so they were going to exclude that evidence from trial because they found the body because of where he told them, but it was on the side of the road, so somebody would have found it anyway. So if it's going to be inevitably discovered, that evidence cannot be thrown out. Also, a good faith exception is where if the police thought they had a constitutionally valid warrant but the judge had made a mistake, they cannot throw that evidence out if the police believed they were behaving with a good warrant. But there are certain times when you cannot be searched and you're protected from searches without a warrant. Your car can't be searched without probable cause or a warrant. You can ask to be stepped out of the car and they can look for weapons in plain sight or pat you down, but they can't search your car without a warrant. Remember that, and we'll talk about it more in the future. Also, an anonymous tip that a person is carrying a gun is not sufficient justification for a stop and frisk. Also, thermal imaging, when they use to look at a house to see if it's abnormally hot because people might have grow lamps in there for marijuana, that's an illegal search. So you can't use thermal imaging. And also, a warrant is needed to use wiretapped evidence. So those are some protections we have from searches. Now we're going to move more into defendants' rights beyond searches and seizures. Biggest one is self-incrimination. When you say, I plead the fifth, it's when an individual is accused of a crime is compelled to be a witness against himself in court. That cannot be required, okay? So they can't force you to testify against yourself, and they must inform suspects of these and other Fifth Amendment protections upon arrest because of the Miranda versus Arizona case. So this is the idea that they have to inform you of your rights, like your right to remain silent, the right to an attorney, before they question you, or else that anything you say can be thrown out of court. Remember that anything you say can and will be used against you in court once they say that. And you're also protected from coerced confessions, meaning they can't beat you to make you confess or deprive you of food for extended periods of time. And they also can't set you up and entrap you and use that against you. So those are some rights that you have. Also, you have the right to counsel, meaning the right to an attorney. The state must provide lawyers in criminal cases according to the Sixth Amendment, even if you can't afford one, according to Gideon versus Wainwright. Even if you cannot afford a lawyer, they have to provide you with one. Now, that would be a public defender, and we can talk about those more in class. Also, the right to a trial. A plea bargain is a bargain between the prosecution and defense for a defendant to plead guilty to a lesser crime, and 90% of cases end in plea bargain because it's cheaper for the state. But this is not a guaranteed right in the Constitution, so you don't have the guaranteed right to get to plea bargain, but oftentimes they give it to you. Juries generally consist of 12 people, but unanimity is not always needed to convict. It depends on the state. And the Sixth Amendment also guarantees a speedy and public trial, but we know that the court system is backed up, so it's not always very speedy. Moving on, also with cruel and unusual punishment, that's forbidden, but know that the death penalty is not considered cruel and unusual punishment, according to Gregg versus Georgia. So that is allowed, but some states choose not to use it, and it cannot be applied to minors or mentally handicapped. Lastly, people argue that there's a right to privacy in the Constitution. The right to privacy is the right to a private personal life, it says live, free from the intrusion of government. But it's not explicitly stated in the Constitution. That word does not appear in the Constitution, but it's implied by the 3rd, 4th, and 9th Amendment, according to Griswold versus Connecticut, which was a case regarding the right to use birth control. And this is what has been used regarding the topic of abortion. Just so you know that abortion cannot be banned due to Roe versus Wade, but requirements can be given to limit people's access to abortion. The trimester limit, where you have to be within a certain trimester, was created in Roe versus Wade. Parental consent, 24-hour waiting period, informed consent, like counseling, are not an undue burden on the woman, so they're okay, according to Planned Parenthood versus Casey. But you can't require the father's permission. That would be putting an undue burden on the woman, according to Planned Parenthood versus Casey. You can't use public funds to pay for abortion, like tax dollars. That would be Webster versus Reproductive Health. And also there's no partial birth abortion, which is a late-term abortion procedure, according to Stenberg versus Carhart. Keep in mind that there are 55% of people feel that it should be legal under certain circumstances, 26% legal under any circumstances, and some believe it should be illegal in all circumstances. Lastly, I want to summarize by saying the civil liberties are expressed in our Bill of Rights, and these are the individual's protections for religion, expression, assembly, and the accused against the government. Legislatures and courts constantly define what the Bill of Rights protects in practice, so it's constantly changing. The end.